Hi, my name is Andrea Aguilar, and I am an estate planning attorney. And generally, families come here and they're worried about their assets. They're worried about their businesses, what's going to happen if I die. And it's not that they forget, but they don't realize that the most important thing that they should have is some type of protection for their children. When emergency happens, are your kids protected? And before we begin, a disclosure, I'm not giving you legal advice, even though I am an attorney. Please, if you have questions, schedule a meeting with us or speak with your attorney about how you can protect your children. So, like I said, the concern is that many clients come and they think like setting up an estate planning is so expensive, and they delay it and delay it. They are always thinking about there's going to be a better time to set up a plan to probably create a trust. But they don't realize that they should be protecting their children sooner rather than later. So what may happen to you? So you may die, and you know that, and nobody's expecting to die. If you have minor children, chances are that you're still young. So you are not thinking about your death, but that may happen. Also, you may become incapacitated. You're going to leave your child in a situation that your child is going to be unprotected, and probably their expenses need to be covered. And if you sadly die, then they are going to inherit some type of assets from you. So what is going to happen with them if you do not have a plan? Simple. The judge or a judge, a particular judge in the place where you reside, will take care of matters or your affairs for you. If you have died, then a judge is going to start, or your family, your successors, will have to start a process called probate to transfer the assets. And if you have a minor child who's going to inherit your assets, then in addition to this process, you're going to have to start, or your family members will have to start this process called guardianship, because a minor cannot manage their assets. So that is simple. So you're going to end up with two processes: guardianship and probate. Guardianship for your minor children, and a probate process. The probate process just says who will inherit your assets. Okay, so if you have certain assets, there are rules in Florida. This is a plan where you have done no plan. So I'm talking about this scenario. There are certain rules that say who is going to inherit your assets in the state of Florida. If you are married, your spouse will get 100% of your assets. Okay, so if you die and you have a spouse, you start this process and your spouse is alive, she's gonna get everything, or he's gonna get everything. If you have children from another relationship, not from the current relationship, and you are married, then your assets will be divided. Half will go to your spouse and then half will go to your children. And if you have a minor children, this particular child will not be able to manage the assets that they are inheriting. And that is why you need to start a guardianship process, or somebody needs to start a guardianship process to manage the assets of this minor. Okay, so it's a little bit messy, and you would like to set up a plan to avoid that. So that is just focusing on the assets, how the assets will be distributed. But now let's talk about who is going to take care of your child. And let's kind of continue. I think I have some more information here. Okay, so now first you need to understand that there are two types of guardianships in Florida: guardianship of the person and of the assets. And most people take care of the guardianship, take away the assets from the equation by setting up trusts, by by designating who is going to manage the assets. Maybe you don't create a trust immediately when you set up your estate plan, but later on in your trust, in your will, you say that your executor at the time will create this trust if you have a minor child. It's called a testamentary trust. So maybe you're taking the assets out of the equation. But another thing that you should do is designate somebody who's going to take care of your children. And I want to pause here a little bit, because we live in Florida. We live with a lot of people that are coming from other countries. And whenever I ask them, hey, who's going to take care of your children? They tell me, oh, I don't know. I just moved here and my family really is in another country. So naturally, it would be my mom, and my mom is living in Peru. I don't know. I'm from Peru. I have somebody who said, hey, Brazil. So they're going back to Brazil, or they're going to stay here, but I don't have family members here. So I will need to appoint somebody who's not related to me because I want my child to stay in the US. Okay, so this is just looking at where is your children going to be raised. Will it be in the US or will it be in another country because your closest relatives are located in another country? And that is a possibility. The answer that I always give them is it depends. A court, because there's always a court that is going to have to be involved if we're dealing with minor children, will decide what is in the best interest of the child. And the fact that you have set up this plan, that you have included your wishes in legal documents, will give a judge guidance on where is it that your children should be raised. Of course, there are check and balances. There are paperwork that needs to be filed between courts here and courts of the country where your children is going to be relocated, but that is also a possibility. Okay, so the idea here is that you should start thinking about all these scenarios to keep your children protected. So what's going to happen? Sometimes a guardian is needed not because you are deceased. Nobody's going to distribute your assets. Your assets are there, but your children need some type of protection. So we're going to have to start this process again, an emergency guardianship, because your kids need some type of protection. So those are the things that you really need to think about. And it can be an accident. Last week, I was speaking with a family. They have a particular immigration situation, and they were worried about having to go back to their country, but their kids were US citizens. I'm sure you have seen that scenario as well. So what happens in those situations? Can they appoint somebody and let the judge know that they want their children to be raised here instead of being raised, I don't know, in Venezuela, in another country? Would they want their children to have this opportunity? So can they do something about it? And the answer is yes. You can set up a plan just to protect your kids. And we're gonna look into the different legal documents that we like to prepare. Just focus on the protection of your children. Okay, but before I mention, I just want to go over this slide because there are some considerations that you need to keep in mind. You cannot just appoint anybody. A judge is going to formally appoint somebody who's going to take care of your kids, and they need to make sure that the person that you're appointing meet certain requirements. They need to be financially stable. They have some type of relationship with the children. They will look at their age, health, lifestyle, willingness to accept this responsibility. And just looking at the relationship. If you're going to appoint somebody that is not living in the US, well, this particular person needs to meet certain requirements. What are those requirements? Well, they need to be related to you somehow, your family members. Otherwise, you cannot just appoint anybody. We will leave the judge that responsibility to decide who in Florida can be named a guardian of your kid. Okay. Of course, there are temporary guardians that can be appointed just because of an emergency that happened, but they are, and then you assume the care of your children if then you recover, if this emergency guardian situation arose based on an emergency. Okay, so let's continue. Yeah, I think I already mentioned this. We don't want either the court or the Department of Children and Family, which is the department that deals with the care of children that are unprotected and is in charge of place the children in certain places, even foster homes, where they are going to be protected if nobody is there to take care of them. Okay, so don't think like your kids are going to be unprotected. I mean, if we see a child that needs protection, we can call the police, and then they're going to get in touch with the Department of Children and Family, and they are the one who are going to be in charge of taking care of the children. But you don't have to go through that process, because you can name the people, even if it's your neighbor, that is going to take care of your kid if something happens to you. Okay? Or if you decide to appoint your mom who's living in Colombia to take care of your kids, but in the meantime, while she travels from Colombia to the US, who's going to take care of your child? You can set up this type of documents where you can designate your neighbor as a responsible person to take care of your child. Okay, so what are those documents? And I just want to mention it very briefly. We call it Kids Care Plan, I mean, my firm, to put this package together. They are a series of documents that you can start preparing for your children. The first that I want to mention is the designation of temporary guardian for a minor. We can put it together with the designation of pre-need guardian. Okay, the third one. Generally, I put it together, or it can be separate, because you want to have a particular separate document that says who's going to take care of my child in case of an emergency. I'm driving, I'm going back home, and I cannot take my kid, take care of them because I'm in an accident, and you're going to probably recover. I don't know, hopefully the next day, the same day, in a short period of time. But in the meantime, your baby is in a daycare, so it's going to pick your baby and take care of your baby while you are not able to do so. So we can create a document that is called a designation of temporary guardian for a minor, where you designate anybody that is closest to you to take care of your child. Now, there's another important document that is called the designation of healthcare surrogate, but it's for a minor, where you are saying who, other than you, other than the parents, because another thing that you need to know is that the parents are the natural guardians. Either you, mom, or dad, even if they are not living together, they have the same rights to take care or make decisions on behalf of their children, unless their parental rights are being terminated for whatever reason. Okay? But if that has not happened, even if you're not together, this is something that I always clarify to my clients. Even if you're not together, you guys have the same rights. So if one of you is not available, then the other will be available. Now, these documents are important to name other people as guardians of your children. Okay? Same thing with the designation of healthcare surrogate, and maybe you're very familiar with this because you probably have these documents already set up for you. Sometimes if you go to a hospital, if you need certain type of treatment, they're going to ask you to sign this document, and many people kind of know about this document. In that similar way, you are naming somebody who's going to make medical decisions on behalf of your children. Okay, so it's a very, very important document. The nomination of pre-need guardian is a document where you prepare, and you can file it with court like now, and you tell the judge, hey, if I die, something happens to me, I will name this person. This is going to be the permanent guardian of my child. And even if my child needs to be relocated to another country, it's fine. I appoint this person, and the judge is going to give greater weight to your appointment. So that's the reason why we prepare this document. Another important characteristic of this document is that you have 20 days to start this process. So anybody that sees this document is going to respect the validity of this process, and you're not going to be, or your family members will not be required to start the process immediately. You have a window of 20 days to use this document, and to, let's say the police is trying to see who's going to take care of your child. Well, the person that you designated there has 20 days to start a formal process to appoint a permanent guardian. So it's very, very useful document. And maybe you have heard about this document already, because this is a document that adults can also use. If you become incapacitated, you can appoint anybody who's going to take care of you, of your person. Okay, now we're kind of focusing on the person because, like I said at the beginning, I'm trying to get the money out of the equation. But if you have assets also, then your guardianship process is not going to be just focusing on who's going to take care of your child, but also who's going to take care of your assets. And in that situation, we can have two different guardians. I had a situation where a family died, and then grandparents want to have wanted to be appointed guardians. So one of the grandparents was appointed guardian of a child of the person. They were going to take care of the child, and the other was going to take care of the assets. So that is a situation that can happen. All this is going to be sorted out with the judge. Obviously, you are gone and nobody can hear your wishes, but the point is that you are here right now and you're going to start making arrangements for this to happen in the way that you want it to happen. Another important document that we prepare is the confidential exclusion of guardians. Okay, so this is very important because, I don't know, you may have a particular family situation where you have decided that this particular person cannot take care of my child for whatever reason. Maybe they can take care of the money, but they cannot take care of your child. And I always joke, like, I have 4 sisters. One of them is great, is amazing, but she could not take care of any children. Very responsible, but her mind is designed a different way. She cannot take care of a particular child. But in a situation where your child is protected, they have kind of equal rights to ask a judge and say, hey, I want to be appointed as guardian. And they can have their own values, and maybe you do not align with those values. You would not want this person to be appointed as a guardian. So you express your wishes in this confidential document that later somebody is going to present to court, or just to make your wishes known. So in summary, these are very important documents that you, as a parent of a minor child, should start thinking about having, okay? And it can be done separately. You don't have to include it in your general estate planning documents. This is another question that I have been asked. Hey, Andrea, I heard many people put designation of guardians in the will. Like, why is that? And why are you asking me to prepare all these separate documents? And I was explaining that, hey, your will is designed to be being deposited in court, and is designed to manage your assets and then be used in a probate process. These documents need to be used during your life. You can be at work and maybe for whatever reason, you're not going to be available to take care of your children. So it's better to have these documents separate. And also, probably you have other provisions, either in your will or your trust, that you do not want to share with everybody. I don't want to share with everybody that I have a company, that I want this percentage to go to this individual. I want this type of distribution. Well, these documents, the ones that you are looking at right now, are designed to be shared. Okay, so we generally do is we prepare a binder, a small binder for these documents. We put electronic copies, and we tell our clients, make copies of all these documents. Keep the originals in a place. We're not going to make 20 originals. We just make one set of originals. But share copies with all these people that you have appointed, because they need to know that they have been appointed, and they need to have a copy to show up and say, hey, by the way, I'm responsible of this child. Okay, so there are different documents not meant to be included with your complete full estate planning documents or within the trust as an additional clause or your will. Okay. Also, you may have different children, and they're gonna become adults in different ages, and you will know that this particular set of documents will have no validity after they become adults. So we prepare separate documents for each child, but you can include this also in your general estate planning documents, your wishes, but just know that you're gonna have to share the whole document to whoever needs to see or learn about your appointments. Okay, so now, hopefully now you start thinking about, okay, I need to do this for my kids. But let's talk about, we didn't talk about your assets and how you can keep separate the designation of who will take care of your children and who's going to manage your assets. Obviously, we try to keep you away from court, and we are going to do that. No matter what, you're going to end up in court to designate the guardian. That is part of the process. But you will have time. And like I said, you're going to separate your assets, and then the process will be easier. This person will start managing your assets automatically and maybe paying the expenses, and nothing is going to stop. In the meantime, you're going to have a designation of pre-need guardian. You're going to have a period of time where your guardian is going to take care of your child and is going to start the process. So everything is going to be organized. Okay. And now that you have these documents, we're going to try to ensure that your family is not separated. By having everything organized, we're going to avoid, financial delays. Payments are going to be done on time. Emotional trauma, there's always going to be emotional trauma if something happens to you, if you as a parent are not available. But hopefully with this planning that you're going to set up, then your family is going to be, it's going to feel a little bit better about the whole situation, because everything is going to go smoothly. Yeah. And one thing that I want to mention, whenever we set up a package, kids care plan, we always add a lot of questions, instructions, and we ask our clients to start getting organized. Like we had a form that says, hey, who are the doctors of your children? Like who is the doctor, addresses, what are the medical records? And they start realizing, oh, yes, I have everything, but I always ask them, do you have it in one place, everything together? So when you are not available, then we are able to give this to the next person. So the point that I'm trying to make here is to avoid all these delays and emotional traumas and all these problems that may arise if you're not available. Start getting organized. And you don't need to hire me to start getting organized. Just grab a binder, put everything that you need to put there that is related to your children, to the care of your children, so the next person can take over, okay? Another thing that we include in that binder is a lot of questions about what are your family values? Where do you want your kids to go to school to? Where do you want them to be raised? Imagine this. Your kids are 5 years old. You're gone. Somebody's going to take care of them. Somebody's going to raise them. How do you share your vision, your ideals, your goals, your values with them? So I add a questionnaire and I say, hey, complete that and leave that to the next person that's going to take care of your kids. Or record a video. Now everybody records a video, TikTok video, an audio, something. I know nothing probably is going to happen to you, but at least you're going to have the peace of mind that you have left something written down for them, something that they're going to hear. And maybe you, 20 years later, going to hear and say, hey, I did this for them and this doesn't cost any money. You can start doing that now, at least to share something important that you want your kids to remember in the future. Okay. So talking about separation, we know that we're going to have to go to court and a judge is going to appoint a permanent guardian for your child, but we don't have to wait for a judge to decide what's going to happen with your assets. I'm sharing this diagram. This is my favorite diagram because it helps me share how your assets are going to pass in a case of incapacity or death. Do we need certain documents to give control of our assets to somebody? And that is a question that I always like to respond by sharing this. Imagine these are all your assets. All your assets are in this bucket on the left side. If you have assets that are titled as joint ownership, meaning you have another owner, a co-owner, maybe your spouse, or these particular type of assets that are under joint tenants with rights of survivorship, then you really don't need neither a will or a trust or a power of attorney. You don't need anything really. If you die, the property is going to be transferred automatically to the person that is also an owner of the property. That's why we're talking about joint ownership. If you become incapacitated and the other person is available, well, this person has control over these assets. So you really don't have to do much there. So in this gray bucket, just make sure that everything is in order and that the other person is also available. Because that person will take care of the assets, will assume control of the assets and ownership of the assets. Okay, so this type of ownership is common with husband and wives. Okay, principal home, bank accounts, maybe companies. But what happens if both of them become incapacitated or die? Well, then there's a problem, and yes, you have to think about something else, okay? But if just one of them becomes unavailable, there's not really a problem. Now, there are other assets that have designation of beneficiaries. So now let's focus on this purple bucket. These assets are generally your life insurance, 401k, retirement accounts, bank accounts. So I have clients that say, hey, Andrea, I have this account, but don't worry. I mean, I already appointed somebody and my assets will go to my children, for example. I appointed my children as beneficiaries. And I always ask them, are they minors? Because you know that minors don't have legal capacity. And for this minor to have control of these assets, you will have to, or somebody will have to start a guardianship process to take care of these assets. So start thinking about that. Also, life insurance, my favorite. I have people that say, hey, my child is 9 years old, and this child is going to receive $500,000 from this life insurance because I have life insurance. I have this particular life insurance that is just a term life insurance. And I love it when my clients come and they are ready. They say, hey, I purchased, I mean, not a whole life, but a term life insurance because I know that if something happens to me between these years, my child is going to be protected. Okay, so if I die, then my child is going to receive this life insurance. And I always say, oh, great, amazing. You're thinking about your children. They're going to be protected. But then they say, hey, who is the beneficiary? Is that a trust or something? No, it's just my children. Then I tell them, hey, now we're creating an appointment with a judge, a guardianship judge, because we're going to have to deal with the fact that your child is a minor. Okay, so that's something that you really need to think about. And also, these direct designations of beneficiaries are great. This is a type of planning that I advise for people that are not really ready to set up a trust and they don't have maybe the money just yet. They want something simple. So I always advise them that while you're alive, nothing is going to be distributed. Okay, this is only relevant if you die. All these designations are going to be effective if you die. Okay, so what happens if you become incapacitated? Well, if this is part of your plan, make sure that you have power of attorneys set up. So you designate somebody else to access these accounts, the bank account, for example, and take care of your children, cover the expenses of your children, or pay for your expenses in general. Okay, so it needs to be complemented. That is the point that I'm trying to make. And everything else would go to this light blue bucket, and it will be transfer managed in different ways. And I think you guessed it, you already know a judge is going to have to be involved. Unless you have a trust, you see at the bottom, I have a trust. There's no court involvement. That's why you see an X there. There's no court involvement, but there is a need to start trust administration, meaning a successor trustee will have to be involved, and they are going to control the assets, and they are going to cover all the expenses needed to be paid. If your children has been appointed as your beneficiary, then they are going to manage all the assets for the benefit of your children, and depending on how you have designed this trust, they will receive the assets when they become adults. Okay, so I think, let me see, don't see messages here. Okay, perfect. So let me continue. Okay, we're close to the end. Like I said, this was gonna be a short session for you to kind of start getting organized. Just wanna leave you with this. I mean, you're planning for life, for your life, for your children's life. So having something set up will give you a peace of mind. So start thinking about starting with this. I mean, maybe you're not ready for a comprehensive plan. If you are, we'd love to talk to you and help you because, I mean, we start like this. We start understanding what is your family situation. Do you have minor children? Do you have adult kids? Are they married? What are your goals? And then we continue with having an understanding of your assets and having an understanding of what you have done, what you have in place. Maybe you don't have a trust, but maybe you have a property and you have created a Lady Bird deed, or you have a company and you want to avoid probate. Maybe you have minor children that are going to inherit this, or maybe you have children that are going to inherit businesses, but you have other partners. So how do you protect your kids? How do you ensure that they are going to succeed you, that they are going to take over this business and that they are going to continue the family business, for example? So I want to leave you with this. You can book a call with me. You can always schedule something with us to talk about your particular situation very briefly. This is not a consultation, it's a brief call. So please, you can schedule a legacy-free call and we can talk about your particular situation. We'll do our best to give you some guidance. And we'll do our best, always try to put reports there or videos there so you can be informed. But if you want a full session, a consultation, we can also schedule a legacy session. Okay, so I want to thank you again for your time. And if you have a question, please post it. Otherwise, we will see you soon.